So a new case has been distributed to the Supreme Court for conference. This case involves whether the federal law prohibiting nonviolent felons from possessing ammunition and firearms is in fact unconstitutional. So let's talk about this. But real quick before we jump into this video, if you think the Supreme Court needs to strike down more gun control laws, go ahead and hit that like button and subscribe. Also, I want to thank the sponsor of this video, which is Kershaw Knives. Kershaw makes some of the best EDC knives available on the market right now, and I carry one of their new knives, the Iridium knife, every single day as my EDC. And right now, if you go to Kershaw Knives, you go to their website and you use the code 23scholar20, you can get 20% off of your order and free shipping on $100 or more. As I mentioned in the intro, in this video, we're going to be discussing a new case that is currently distributed to the Supreme Court for conference. This case involves whether the federal prohibition on possessing ammunition is valid under the Commerce Clause. The plaintiff in this case is challenging whether Congress may criminalize intrastate possession of ammunition solely because it crossed state lines at some point before it came into the possession of this individual. Now, the facts around this case are pretty absurd, and it's really interesting the facts that led to this case now making its way up before the Supreme Court. Mr. Seekins, a homeless individual, was arrested on suspicion of stealing a U-Haul, and that was back in June 17th of 2019, and this was in Texas. Mr. Seekins was a homeless individual, and he was homeless at the time of his arrest, and he survived by collecting things out of trash cans and dumpsters and then storing them in a U-Haul truck that he ultimately also slept in. When the police searched Mr. Seekins in this U-Haul, they found multiple items including flashlights, old and destroyed cell phones, lighters, spyglasses, and just a lot of other things. But the item that they found, which is specific to this case, was an orange 12-gauge shotgun shell and then also a flare launcher. When asked why he had the shotgun shell, Mr. Seekins said that he found it in a dumpster. The shotgun shell in Mr. Seekins' possession looked almost identical to a flare gun shell, which the officers at the time initially identified actually as a flare gun shell. They didn't believe it was a shotgun shell, so they really didn't pay it any attention. Also in the cluttered U-Haul, they found some wrenches and some other items, and then they also found that flare gun. Mr. Seekins alleged that he found this flare launcher and these shells and all these other items in a dumpster, and there really is no evidence to the contrary that maybe he even modified the flare launcher on his own. There is no evidence to say that he actually did it on his own. Because he had prior felony convictions, Mr. Seekins was initially charged with possession of a firearm under 18 U.S.C. section 922G. There, the prosecutor was trying to allege that the flare launcher, which was, in their opinion, modified in some way, they tried to allege that it was in fact a firearm. However, in the lawsuit, Mr. Seekins and his defense gave notice of a proposed expert and the proposed expert's testimony that would show that the modified flare launcher could not meet the federal definition of a firearm. In response, the government and the prosecutor abandoned their initial charge that they based their whole case on and then changed it to a felon in possession of ammunition. Now, the record contains no evidence that there was a commercial transaction of any kind involving the two shotgun shells, nor does the evidence show that Mr. Seekins has in any way moved the shotgun shells across state lines. The government made no effort to prove that Mr. Seekins stole, bought, or planned to sell the pair of shotgun shells, and it made no effort to show where, when, or how these items came across state lines into the state of Texas. The government only presented a witness which could show in some way that the company who manufactured the shotgun shells most likely maybe did it and manufactured them in Illinois. But again, there was no concrete evidence that they were manufactured in another state and then crossed state lines into the state of Texas when they came into possession of Mr. Seekins, who allegedly found them in a dumpster. But as a result of this, Mr. Seekins was sentenced to 70 months of incarceration under 18 U.S.C. section 922G1 for being a felon in possession of two shotgun shells that he found in a dumpster. Pursuant to Congressional Commerce Clause power, section 922G1 makes it a federal crime for anyone previously convicted of a felony to possess in or affecting interstate commerce any firearm or ammunition, or to receive any firearm ammunition which has been shipped or transported in interstate or foreign commerce. So originally he sought an appeal up to the Fifth Circuit and a 3-judge panel ruled against him. Then he sought a rehearing from the en banc panel in the Fifth Circuit. Now, Ultimately, that review was denied by the Fifth Circuit en banc panel. There were some dissents who wanted to review this case, but they were overridden by a 9-7 vote, which ultimately denied Mr. Seekins a rehearing by the Fifth Circuit. In response to that denial of the rehearing in the Fifth Circuit, Mr. Seekins is now petitioning the Supreme Court to review this case and review whether 922G1 as applied to him is unconstitutional. Recently, the Supreme Court held that under the Commerce Clause, Congress can only regulate conduct that substantially affects interstate commerce or has another evident commercial nexus to interstate commerce. Here in this case, it appears that Mr. Seekins is trying to springboard off of the 1995 landmark case United States v. Lopez. In the Lopez case, a teenager, Alfonso Lopez, was arrested for carrying a concealed weapon into his high school. He was charged under the Gun-Free School Zones Act of 1990, which was a congressional law that banned people from bringing guns into school zones. Mr. Lopez challenged his conviction, arguing that the law exceeded the Congress powers under the Commerce Clause. In a 5-4 decision, the Supreme Court on review agreed with Mr. Lopez and struck down that law. But then after that decision, Congress went in and passed a new Gun-Free School Zone Act. They addressed some of the issues that the Supreme Court specifically focused on in the Lopez decision. But this is one of those cases that is trying to springboard off of that language, and also some of the recent interest that some of these Supreme Court justices have put forward in maybe addressing the Commerce Clause, revisiting these issues, and once again trying to constrain the use of the Commerce Clause. In his petition to the Supreme Court, he states that the unique factual situation involving just 2 shotgun shells found in a dumpster highlights the purely intra, which is within a state, character of this case, and the dramatic consequences of this law's application when compared to previous challenges to Section 922G. It's hard to imagine a more local crime than this. So this is an interesting challenge that will impact Second Amendment rights without actually bringing a pure Second Amendment challenge. And the Supreme Court will have to make their decision on this soon. Currently, this case has been distributed to the Supreme Court for conference, and that will take place on June 22nd. A Supreme Court conference is when the court gets together and decides if they want to grant review to a case or ultimately if they want to deny the case review. Only 4 justices are required to grant review to a case. However, keep in mind, out of the thousands of cases that are submitted to the Supreme Court every single year, they only accept about 100 to 150. So it's still very hard to get Supreme Court review. Recently, however, I do want to note that the Supreme Court's Sackett v. EPA case was very interesting and also brought up the concerns that some of these Supreme Court justices have with the use of the Commerce Clause. Many of the justices in that decision signaled that they would like to drastically rein in the use of the Commerce Clause as a justification for these types of restrictions. This could be a case that the Supreme Court wants to grant review to because of the strange facts that ultimately led to this lawsuit, and also because it deals with the Commerce Clause. The Supreme Court is much less hesitant to want to take up Commerce Clause cases, whereas traditionally they have been much more hesitant to want to deal with the Second Amendment and pure Second Amendment challenges. Again, last year we got the Bruin decision, which was awesome, but it's yet to be seen if they want to take up another Second Amendment case. So right now we're going to wait for the conference, which will take place on June 22nd in the Seekins case, and then usually the following week we will get an order from the Supreme Court on whether or not they want to grant review to the case or not. But if we get any more information, I will let you all know. If you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this Cyber2A news. As always, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.